It's a decision of the District Court of Munich that was delivered in September, the beginning of October last year. I'm going to explain in a moment why we have two different dates mentioned here in the slide. The case was between InterDigital as the claimant in these proceedings, the patent owner, and on the defendant's side was Amazon. Now, what happened here, what was particularly relevant for understanding these proceedings, we had negotiations between the parties about a license to InterDigital's portfolio, which did not lead to the conclusion of an agreement. So at some point in August 2025, Amazon launched proceedings in the UK, asking the court to make a determination of front terms and conditions for a license to InterDigital's portfolio. What is interesting to mention here and keep in mind is that initially this action was limited to a license for UK patents only, so it was not a global, it had not a global reach. A reaction of InterDigital to that rate determination action in the UK was to file a motion for interim measures before the District Court of Munich. That happened on the 24th of September 2025, so almost a month ago, three weeks to a month after these proceedings were launched in the UK. What InterDigital sought in these proceedings, and we're going to look at that in more detail in a moment, it sought what we described already as an anti-interim license injunction. Maybe here some background. There has been a practice of particularly the UK courts in the last year and a half to grant declarations that refer to an interim license, which means that UK courts have, very simple words, said that under certain circumstances, the patent owner should have been obliged to grant an interim license to an implementer, with all the consequences that this could have for proceedings both in the UK and in other jurisdictions. And the motion that InterDigital filed here was directed to this type of remedies that can come from the UK court. So it wanted basically to prevent an application that is related to an interim license being moved forward in the UK. This motion was filed again on the 24th of September, and the Munich District Court granted a respective interim injunction 2 days later on the 26th of September. Interestingly, this injunction was granted ex parte, which means that Amazon, before the court granted the injunction, was not heard, was not involved in the proceedings. Then what was also interesting here was that this interim injunction, days later, on the 1st of October, was changed a little bit. So the court particularly specified the operative part of the interim injunction. So the actual order basically made some changes there. But at the end of the day, the reasoning behind the final date in which the judgment was delivered, so the final interim injunction was delivered on the 1st of October 2025. So these are this is the order we're going to work with today, but the reasoning was already delivered with the first ruling on the 26th of September. Now, we said this is an anti-interim license injunction, and I think it's interesting before we go into the reasoning to see what the court actually ordered here. There were 5 points which were included in this order, and the most interesting for us, focusing particularly on this interim license applications, are point 1 and point 2. So Amazon was asked or ordered by the Munich court to refrain from seeking a provisional order at the UK court that would require InterDigital to grant Amazon an interim license to German patents, as far as such order can and would prevent InterDigital from conducting infringement proceedings in Germany and or enforcing any resulting judgment. So the first thing that the court asked Amazon not to do is to file for an order that would require InterDigital to grant an interim license. The second point was very similar to that one. Here, the court asked or ordered Amazon to refrain from seeking a provisional order at the UK High Court that would declare that InterDigital breaches its FRAND obligation if it does not grant an interim order to the German patents on the terms that the UK court would settle. Again, as far as that order would prevent InterDigital from conducting infringement proceedings in Germany or enforcing any resulting judgment from this type of proceedings. So here, it was not about an order that would grant an interim license to Amazon, but it was a slightly different angle. It would be an order that would declare that if InterDigital would not grant such an interim license, it would be in breach of its FRAND obligations. Of course, with the consequences, the legal consequences that this entails. Then the rest is also maybe interesting to take a quick look at as well. Point 3 is maybe a bit difficult to understand because Amazon has been ordered here to refrain from not withdrawing any application under paragraphs 1 and 2, which, if we look at maybe in the right way, what it entails basically is an obligation to withdraw any applications that could be directed to an interim license within 24 hours after this order had been serviced, or take any procedural steps that would finally revoke such applications with effect for Germany. Then the order also in point 4 requires Amazon to refrain from continuing any interim license proceedings with effect for Germany, with one exception, basically taking measures to withdraw respective applications. And we have also finally point 5, which asks Amazon to refrain from indirectly forbidding InterDigital to conduct patent infringement proceedings in Germany based on a court or any administrative order. So I think this is a bit broader than just the interim license proceedings that are pending before the UK High Court or that could pend before the UK High Court. But at the end of the day, the most important elements for the interim license questions were points 1 and 2. So to sum up with this order, Amazon was required not to seek a provisional order that would either grant an interim license or would declare that InterDigital was breaching its FRAND obligations if they didn't grant an interim license that would cover also the German patents. Now, what's the reason for granting this order here? What was the reason? What was the justification of the court for granting this interim relief? Here, maybe generally, before we go into the details, under German law, when we have measures, we have basically 2 requirements that need to be met. So on the one hand, you need to have a claim or an action that needs to be protected by measures taken rapidly in order to prevent losses or to prevent rights to being excluded. So you need to have a right which is worth to protect. And on the other hand, you have also to have this element of urgency when it comes to interim measures. So you need the court to act quickly in order exactly to prevent any loss of the right that could occur in the meantime. The court examined both of these requirements, of course, here in the present case as well. And regarding the first one, whether there is a claim that's worth protecting here, the court identified what it called property-like legal positions of patent owners that could be impaired by a motion involving an interim license. When it says property-like legal position, it basically means the rights arising from a patent, particularly arising from the German patents that are relevant in the present proceedings. But at the end of the day, the finding of the court was here that filing a motion before a foreign court, which would involve an interim license, is a tortious act as far as German patents are affected, because exactly it impairs this property-like legal position of patent owners. And the court addressed in this context both options that we discussed already, both the case where the foreign court would actually grant an interim license, but also the cases where the court would declare that not granting an interim license is a breach of FRAND obligation. Maybe what is interesting before we go into the details, even the filing of a motion that would involve an interim license was seen as a tortious act. The court did not consider an order granted by a foreign court concerning an interim license to be problematic. It said that even before that, even filing this motion is a tortious act, impairing the property right legal position. The filing itself is problematic. It doesn't need to come to a decision, to come to a foreign court's order that involves an interim license or sets an interim license or makes a declaration to have the legal rights impaired. Just the fact that you're filing such a motion as an implementer is sufficient. Now, what would be the impact if we had this type of claims being granted in a foreign court? When it comes to this first option, so if you had here, particularly the UK High Court ordering the grant of an interim license, the court, the Munich court, found a clear case that InterDigital would be impaired from fully and successfully enforcing the patents that it holds in Germany for a non-negligible time period. Why? Because if the foreign court, if the UK High Court would grant an interim license, then Amazon would likely be able to invoke this license, this interim license, as a defense in German infringement proceedings, at least for the duration of this interim license, at least for the time in which this interim license would be in force. Which means that if InterDigital would initiate legal action, infringement proceedings in Germany based on German patents, if this interim license was granted by the UK court, these actions would likely be dismissed as unfounded, exactly because there is a license in place. So this was the first risk that the court identified here regarding the position, the legal rights coming out from the German patents. What happens with the second option concerning an interim license we discussed before? So we had the second option would be to have a declaration that not granting an interim license would be a violation of FRAND duties. Now, this is a bit different from the first option we discussed already, because you don't have really a grant of a license here. This possibility to invoke that interim license as a defense in infringement proceedings likely would not be there. But does this mean that it is not relevant, it is not harmful? The Munich court found that this is not the case. Here, the court saw also a risk for the legal position of the patent owner, because it said, well, if you look at the judgment, if you look at this type of judgments, then you might get the impression that there is actually no interim license granted, and there is also no, let's say, obligation to grant an interim license. However, actually, the patent owner does not have a real choice not to grant an interim license in this case, because if they would not do that, then it would most likely lead to a situation where the UK patents would not be enforceable before the UK court. Why? Because the court would have established that the patent owner that has not granted this interim license is not willing, is violating its FRAND duties, and therefore, of course, the enforcement would be barred of the before the UK courts as well. So at the end of the day, if you look at the combination of both, the District Court of Munich said, actually, what you are doing is putting the patent owner in a dilemma. So they would need to select either between limitations of rights of the German patents or of the UK patents. And in the eyes of the court, this was something that was not justifiable. So it would be impairing the property rights, the property-like legal position, as the court put it here, to an extent that was not acceptable. That was the main reason why the court decided to grant the injunction here. Then turning to the second element we mentioned before, the question of urgency, the court also found that urgency was given here. So there was a need in the eyes of the court to have measures now, granted now, because otherwise it would be too late, if we want to put it simply. Now, what was the reason? Why was this? Why was there an urgent need to do something right now? If you remember, we said that in the UK proceedings, the claims that Amazon had raised were limited to the UK patents. So the German patents, which the court of Munich needed to protect here, were not directly impaired by these claims, because again, the UK proceedings were limited to the UK patents. So there was no infringement there now. But the court said Amazon's conduct, the way it has behaved, establishes a risk of first infringement, which is, again, a sufficient ground to accept that there is urgency, that there is a need to grant interim measures. Which were the reasons for assuming that? The court looked at the overall circumstances of the case. On the one hand, the behavior of Amazon, and on the other hand, the behavior of the UK courts, and found that these overall circumstances indicate an imminent threat that the claims, as they are now, limited to UK patents, can be expanded to a global portfolio, in which case the German patents would be affected as well. It mentioned some factors regarding Amazon's behavior that indicate this imminent threat. Two of these or three of these aspects were redacted in the judgment, but the one that was mentioned, it's interesting that the court said here, of course, the claims might be limited to UK patents, but if you look at the submissions of Amazon in the UK proceedings, you see that they refer to InterDigital's entire video portfolio, to the global portfolio. So this was seen as an indication that there is a threat that the claims are going to be expanded, and the interim license would be expanded also to the global portfolio, including the German patents. Then the risk that this could happen and the risk that this could go through was also indicated in the eyes of the Munich court by the fact that the courts in the UK have given declarations in the past involving global interim licenses. And the court also recognized here no indication that the UK courts have departed from this practice. So here, the court, on the one hand, again, said, if you look at the pleadings, if you look at the case, there is a threat that you can expand the claims also to cover an interim license for the global portfolio. And if you do that, there is a big threat that the UK courts are going to go with that as well, because they have done that already, and there is no indication that they have changed their mind or changed their thoughts of how to deal with these situations. So this was then the court's thoughts on the urgency issues, and by that the court had examined these two basic requirements, so the interim injunction could be granted here. Before we close, just one last point that is interesting. The court mentioned in a paragraph that in case you have an implementer who would seek before a foreign court an order requiring either the grant of an interim license or a declaration that the patent owner who has not granted an interim license is violating its grant obligations, and these declarations or these orders would also affect German patents, then this implementer could be seen as unwilling. So the court here did not say that Amazon was unwilling in the present case, but it reserved the right to consider implementers that do something similar as what the court discussed here. So as seeking this type of interim relief abroad with the goal to go into the direction of an interim license, it could be that these implementers are going to be considered unwilling. Now, this has broader implications than just a potential anti-interim license injunction that we had here in these proceedings, because it could have implications on potential infringement proceedings in Germany. What could be that? What could be these implications? Particularly if you have an infringement trial and the court accepts or establishes that there is infringement of the patent, if the implementer has already been seen as unwilling because it has sought abroad these interim license applications, then it would be very likely that the front defense in the German infringement proceedings would be very limited, if available at all, which could, of course, lead to an injunction or patent infringement. So this is a note of the court here, which might indicate that initiating this interim license proceedings or proceedings related to an interim license abroad, independently of the claims that the concrete claims that are being raised, can have an implication on the broader case, especially also on infringement proceedings, and might put the implementer's position in danger or create a risk there of being seen as unwilling. How strong this or how serious this risk is, I think it will probably is to be decided on a case-by-case basis, but maybe just for us to have a complete picture here, in the past, the Munich District Court, in similar situated cases where the interim measures should address anti-suit injunctions that would come from foreign courts, from particularly Chinese courts or even US courts, had taken this view that the implementer that seeks an anti-suit injunction is an unwilling licensee. So it did not just reserve the right; it had made this. It had established that already. So in this sense, this note here is not something particularly new, but it seems to be in line with the previous case law of the District Court of Munich when it comes to interim measures against this type of remedies that come from abroad and constitute a risk to the infringement proceedings in Germany or the enforcement of patents in Germany.